Bonjour, merci et bienvenue à cette conférence virtuelle des Midis-conférences des jeunes chercheurs du Centre de recherche en droit public. Aujourd'hui, pour cette conférence, nous accueillons Michaël que j'ai l'honneur de vous présenter. Michaël est membre du barreau de l'Ontario et diplômé de la faculté de droit de l'université McGill et de l'université de l'Alberta. Ses recherches portent sur la manière dont la technologie modifie les soins de santé, en particulier les applications mobiles de santé, l'intelligence artificielle et la responsabilité professionnelle. Michaël est largement intéressé par la façon dont les technologies affectent la relation entre les médecins et leurs patients, par la façon dont la loi comprend l'identité de la personne et par la façon dont les humains interagissent avec l'environnement naturel. Sans plus tarder, je cède la parole à ma collègue Eve Gaumont pour qu'elle puisse vous présenter la conférence de Michaël. Merci.
Artificial intelligence as a transparency problem. It has been said thousands of times. But what does it mean for automated decision-making in the context of administrative law? The talk we're presenting to you today really gets down to brass tacks on this question. Michael Lang starts his presentation with an overview of AI and its black box problem. Then, taking the example of a decision regarding an immigration application visa, he discusses procedural fairness and the right to be provided reasons for an administrative decision. Finally, he touches on the right for an explanation proposed in Quebec's Bill 64 as a solution to the explicability problem of AI. Michael is good at explaining things in a clear and educational way. We really enjoyed this presentation, which lies at the confluence of Canadian administrative law and artificial intelligence, and we hope you'll like it as well.
My name is Michael Lang. I am a master's student at McGill University in the Faculty of Law. I'm really happy to be here to be putting together this short presentation. Before starting, of course, I'd like to really thank the series coordinators as well as the CRDP for putting this together, for providing a space to discuss these ideas, to refine the topic that I'm working on, and to develop a short paper, sort of setting them out in greater detail. So thank you for that. It's a great opportunity, and I'm happy to be here. The topic I'd like to focus on is the interface between artificial intelligence and the administrative state. As I'm sure everyone knows, artificial intelligence is affecting numerous aspects of our society, numerous aspects of the way we relate to each other, the way we build value in an economy, and the way that we relate to our governments. Artificial intelligence has received all kinds of attention in recent years, and that attention just seems to be gaining steam over time. It is promising to completely reshape much of our society, and as it does, as it reshapes the way we relate to each other, it also raises all kinds of important legal and ethical questions. And the subset of legal and ethical questions that I'd like to write about and that I'd like to discuss here in this talk are those that are raised when these artificially intelligent decision-making systems are used by the administrative state. So the talk is going to, I hope, consist in three broad parts. In the first part, I just want to give sort of a very brief general overview into artificial intelligence, and specifically to touch on the ways machine learning algorithms that produce decisions or that operate as decisional aids, face an inexplicability problem. That is, these systems make decisions, and the reasons for which these decisions are made are unknown and are oftentimes, because of the programming that goes into developing these systems, are unknowable. So this, I think, creates a few problems, and the specific problem that I'd like to talk about in the second part of the presentation is the problem that gets raised when these decision systems are used by administrative bodies in the administrative state to make important decisions covering a wide number of topics, especially for issues like immigration or access to elections. I think that the tendency of these systems to sort of operate with unknown and unknowable reasons is a potential problem insofar as administrative decision makers are oftentimes bound by the duty to give reasons. This is a duty of procedural fairness. It's a duty I'll outline in the second part of the talk, and I will hopefully sort of link up to machine learning and describe how machine learning might make the realization or the sort of the discharge of this duty significantly more complicated than it already is. In the third and final part of the talk, I want to briefly give an overview of one proposed solution to the inexplicability problem faced by machine learning systems, and that's the right to an explanation. This, at least in the context of this talk, will be sort of a statutory right developed by legislatures that provides individuals who are the subjects of decisions made by machine learning algorithms a right to access the reasons or a sort of a list of criteria that were considered by the ML system when delivering its decision. I'm going to talk about whether the right to an explanation, as it's been proposed in Quebec and elsewhere, is a reasonable way of addressing the inexplicability problem that gets raised in the administrative law context. So, to begin, in the first part of the talk, it sort of goes without saying that artificial intelligence is perhaps the most significant technological shift since the internet. It might even be the most significant technological shift in our society since the invention of something like the cotton gin. We've spent a lot of time in civil discourse in the last sort of half decade discussing artificial intelligence, thinking about the ways it's going to be affecting our lives and the kinds of decisions it might make and the way that those decisions are likely to impact all kinds of rights and services that we access. As I said, I want to mostly focus in this talk on the way artificial intelligence raises unique ethical and legal issues in the context of public law. So that's when artificially intelligent systems are used by public decision makers exercising public authority, particularly in the administrative context. Of course, these tools are being used increasingly frequently by all kinds of governments, and it is almost certain that decision-making systems, artificially intelligent decision-making systems, are going to be used increasingly commonly in the years and decades to come. Of course, there are many reasons for this. One principal reason, a reason that I hope I'll come back to in the third part of the conversation, is that machine learning and artificially intelligent systems promise to sort of increase the efficiency with which decisions made by public bodies get discharged. So, of course, machines think much more quickly than human decision makers do when we're dealing with sort of widespread backlog in the administrative state, overtaxed, overburdened decision makers who sort of have large piles of files to get through. The promise of artificially intelligent decision-making systems is to really increase the efficiency with which important decisions are made by the administrative state. So I've been sort of vacillating between using the term artificially intelligent system and machine learning. I've also sort of used the acronym ML to refer to machine learning systems. Now, machine learning system is a subset of an artificially intelligent system. Machine learning really just refers to that subset of artificially intelligent systems that learns on its own. So these are systems where you plug in a bunch of data, you plug in a few sort of basic introductory parameters, and then the machine does the work for you. It teaches itself, it learns how to draw connections and to draw causal inferences from the data set that you're giving it. So machine learning systems as a subset of artificially intelligent systems are just sort of part of the AI landscape, but they're an important part. And they're an important part for, at least in one respect, because many machine learning systems are unexplainable. This is sort of at the heart of the talk that I'm giving, and will be at the heart of the paper that I develop over the coming months. And what I mean by unexplainable is the following, roughly. When a machine learning system delivers a decisional output, so this is for example, let's think about a machine learning system that makes decisions about whether to accept or deny an application for an immigrant visa. A machine learning system might sort of produce a decision, a final outcome, a yes or no to the application, as it were. But it's typically, and for a certain subset of machine learning systems, it will be difficult for a human who takes this decision to understand why the machine delivered the decision that it did. In many cases, it will be impossible to know because of the way these systems are programmed, with sort of layers of programming that prevent even the technical designers of these machine learning systems to understand why the decision, why some particular decision was made rather than another. So as one of the many applications of machine learning, as considering that machine learning is one of the applications of artificial intelligence, its scope is going to be sort of contained to some of the more difficult, more sophisticated areas of the administrative state where really difficult decisions need to be made. It's unclear exactly what portion of systems that are likely to be used by administrators are likely to be ML, but as machine learning becomes sort of a bigger piece of the AI puzzle, it's likely that their sort of prevalence in public decision making is going to sort of increase. So this problem, the problem of unexplainability, is often referred to as the black box problem, and sort of just to restate it maybe a bit more simply, the unexplainability of machine learning systems simply means that we don't know how or exactly why these systems reach a particular decision. And this, I think, is a potential problem in the administrative system, and I'll tell you why as we move into sort of the second part of the talk. So administrative decision makers in numerous contexts, and by administrative decision makers, I'm referring to sort of any public body that's delegated authority by statute, by a minister, to make a decision on sort of outside of the sphere of the legislative process. So an example that I've already brought up and that I might come back to is sort of the process according to which decisions about immigration visa applications are approved or denied. That's sort of a quintessential example. It's the example that comes up quite a bit in the case law discussing the rules of administrative law. And I think it's sort of a quintessential and easily accessible example of the kind of decision that I'm hoping to sort of elaborate on as I develop the paper. So administrative decision makers are typically bound by what's known as a duty of procedural fairness. So what that means is that administrative decision makers, since they are since they're exercising public authority, we typically understand that they have an obligation to exercise this power, the power that they've been given by legislation or by a statute, in a manner that's fair. And the way courts have gone about trying to assess whether a decision made by an administrative body is fair is sort of operates in two parts. The first part, and this is set out in at least 3 really major Supreme Court decisions, the Nicholson, Knight, and Dunsmuir cases at the Supreme Court of Canada. The first step is what's called the threshold question. And at the threshold question, a court reviewing an administrative decision maker's process is going to ask whether the kind of decision that's being made by the administrative body is the sort of decision that would tend to attract a procedural right. So this is sort of the basic entry-level question when we're faced with an administrative tribunal's decision. We have to say, okay, is this decision that the decision maker is making of significant enough importance that we should ascribe to it an obligation of procedural fairness? So this is sort of the basic introductory question. I'm not going to spend too much time focusing on it. We'll just sort of assume that for the purposes of this talk that we can sort of ignore the threshold question. We can really focus on those subset of administrative decisions that do meet the required threshold for procedural fairness, and we can move on to the second question. And the second question is sort of once we've decided that this basic threshold has been met, once we've decided that an administrative decision maker's decision-making process it is in fact required to be a fair process. Once we've decided that we think the decision is important enough to require a certain level of procedural fairness, we can then try to determine exactly what kinds of procedures are required to ensure that the decision that gets made is a fair one. And in answering this question, the Supreme Court in the sort of famous Baker decision outlines a number of criteria according to which we can make a decision about whether an administrator has engaged in a fair process. So a court reviewing an administrative decision maker for fairness is going to look at a number of factors. The presence of any one of these factors is determinative. That means that the fact that the decision was made according to one of the procedures listed in the Baker decision doesn't necessarily on its own mean that the obligation of procedural fairness has been met, but it tends to point in that direction. So a court that's reviewing an administrative decision maker for procedural fairness will look at things like notice, whether the decision maker disclosed information to the person for whom a decision was being made, whether the subject of the administrative decision had an opportunity to participate, whether they were given an opportunity for a full hearing, whether they were given an opportunity to present evidence to the administrative tribunal or the administrative decision maker to sort of state their case, to make a claim about their case, whether they were given the right to counsel, and most importantly, in the context of this case, in the context of this conversation, whether the administrative decision maker provided the subject of the decision with oral or written reasons for which the decision was made. So it's this last part that I really want to drill down on in the paper. This has been referred to in sort of the academic literature in the administrative law context as the duty to give reasons. This was introduced by the Baker case. It didn't exist in any sort of formalized way before the Baker decision at the Supreme Court. And in describing it, Justice Leroux-Dubé wrote that in certain circumstances, the duty of procedural fairness will require the provision of a written explanation for a decision. So reasons, what this means is that reasons are not always required when you're the subject of an administrative decision, but they are needed if a particular decision has important significance for the individual. So coming back to sort of the immigration context, it seems as though many of the decisions that are made about whether to accept or deny an immigration visa is a significant decision, and a court looking at the administrator's work might say that in order to make sure that the process is fair in the immigration context, you really do need to explain, administrator, why the particular decision that you reached was the decision that you made. Being cognizant of time, I'm just going to sort of continue through quite quickly over the next few points. Now, Now, the Baker decision at the Supreme Court doesn't tell us exactly what the reasons made by the decision, given by the decision maker, need to look like. For example, it doesn't say whether they need to be of a certain quality. And the law isn't yet clear whether sort of any reason whatsoever would be sufficient to satisfy the duty to give reasons. So we don't know, for example, if just saying, we've denied this application because we decided that the application had no merit. Whether that would qualify as sufficient reasons in this context is not yet clearly established in the administrative law context. So what do we do then for unexplainable machine learning systems that might get used in the administrative context? Because it seems like the reasons for which a decision was made are unknown and potentially unknowable. And this sort of brings me to the third part of the conversation. One potential proposal is a right to an explanation. So Quebec's legislature has been, over the course of the summer, debating Bill 64, a large sort of number of amendments to Quebec's privacy law regime. This includes a right to an explanation. And what this means is that when a public body uses an information system to make decisions about individual interests, it has an obligation to explain why the decision was made and the kinds of factors that the decision system relied on. Now, one potential problem with the right to an explanation is that explanations might be contrived to sort of satisfy a sort of baseline statutory right to an explanation. The reasons given by a public decision maker, in other words, might just be boilerplate. They might be sort of written down by some administrator somewhere, but they might not sort of fairly represent why the decision was made. They might be sort of unsatisfactorily short, and boilerplate reasons might just simply not consist of the list of factors that were actually important for the machine learning system. So we might be concerned that this isn't really what we want in the administrative context in order to satisfy the obligation of administrators to provide reasons. So I think what this points to, and I'll just quickly go through sort of how I see this going in the paper that I'll be developing. For less significant decisions made in the public administrative context, we might just need to get comfortable with unexplainable systems. If administrative efficiency is something that we think is really important and that we think is a good thing, then for decisions that aren't incredibly important, we might start to think that the Baker criteria don't require really fine-tuned, really clear, exhaustive reasons for which a decision was made. We might just need to come to accept that some decisions are not going to be susceptible to reasons. But for more significant decisions, decisions that impact our lives in more important or more less trivial ways, then the right to an explanation might actually be really vital for ensuring fairness, for ensuring that we can review decisions made by administrative bodies to make sure that they're fair, to make sure that that they're not, for example, discriminatory against certain groups of people. In the immigration context, in the election access context, this seems like it could be potentially really important. But in order to actualize this right, we might want to begin thinking about artificial intelligence or machine learning systems as more of a decisional aid or a guide, rather than as something that can replace a human decision maker. So even in contexts where administrative decision makers are going to increasingly be relying on machine learning systems, we might really want to underscore that it's important for human beings to be involved in the process, and to sort of underscore that humans have a really important role to play when we rely on machines to make decisions that impact our significant interests. So I've run slightly over time, and I don't want to go too much further. But in broad strokes, that's the layout of the paper that I'll be developing in the coming months. I'm again really happy to have been able to get this opportunity to present, and I'm looking forward to the conversation in the weeks and months ahead. Thank you very much, and I I would love to get any questions by email or by other means as we continue this conversation. Thanks again.